to admit to having committed this conduct, to having had this gun, to having committed the robbery, and you can't take that back. What you're about to admit to, you can't take back. You're going to be convicted, you're going to be guilty. Never mentions the sentence, which is what we're up here dealing
the
with.
13-minute sentencing
Right.
that the government concedes is procedurally unreasonable.
Procedurally unreasonable, and you know, Your Honor, and I think I mentioned it at the end of my brief, I mean, this is about more than just Mr. Smith. This is somewhat about public confidence in the judiciary. This was a highly deficient Rule 11. This was an appeal waiver that was misdescribed to the defendant, didn't include the sentence, and a sentencing with no discussion of the sentence, and I just don't think it's proper to let that stand.
And also not an outlier in this district, not in this district, in the Eastern District of North Carolina.
This is not, Your Honor, as the government, you know, as Bailey and Abney, which we both discuss in our briefs, came from this same district judge, and the 4 cases the government cites in its 28J letter all come from this same district judge. It's the same plea colloquy, and look, district judges are busy, I understand. I think that was something Judge Richardson pointed out at the CLE on Monday, is how busy they are, and we appreciate that. He has a script, but it's not a compliant script. It's a script that doesn't comply with Rule 11, and there are a lot of judges in the country.
And the colloquy is sort of also limited in terms of a colloquy, you think, a back and forth. There's not that much questioning to understand if the defendant
comparing this, Your Honor,
understood.
I agree 1,000%. Comparing this to other Rule 11s in our district and others, where especially when you get to things like this appeal waiver and there's a direct understanding, do you understand this? Do you understand this? Here he sort of recites some but not all of what he needs to, and then at the end says, is this what you've agreed to? Not even do you understand it, but is this what you've agreed to? It is kind of the equivalent to, and I'm dating myself, but you know, Blockbuster Video, when you'd get the huge contract and you'd sign it.
No, I'm not familiar with Blockbuster. I'm not that old.
Okay.
No, I do know. Go ahead.
It is, I mean, and a Rule 11 proceeding is meant to be more than contractual boilerplate.
So let me outline this the way I'm understanding. You tell me where I'm wrong on it. The first inquiry we asked you about plain error review, you somewhat concede that. I'm not sure you should, or whether or not we view it that way, because we're definitely somewhere in a minority view on that. The other circuits have all gone somewhere on it. The First Circuit has gone with it. It really seems like we're in the business of whether we're determining this a knowing and voluntary standard as opposed to the plain error. But be that as it may, the question then becomes, well, under the totality of the circumstances, was his appeal knowing and voluntary? He certainly answered to the judge that he understood it in terms of the Rule 11B, that even though the judge didn't go through all of the colloquy he is supposed to, that really is very rote and is it's not even understandable why a judge wouldn't pick up a piece of paper and read what everybody does. It's not the first time, so it really is appalling to see that aspect of it. But if we say it's knowing and voluntary, that kind of ends it. If we don't, then we proceed, I think, to a question you probably ought to at least touch on, is that appeal waiver severable from the rest of it?
Yes.
And so if it is, then we get to the procedural reasonableness, unreasonable aspect of it, and possibly the remand of the case. So is that sort of where you're going with this?
That is, I'm glad I have time to get there, Your Honor. First,
no, you already did. I've already put you there. There's not a lot more elaboration on that, except to the extent that you can give us something additional to what I've just said.
And here's what I would say. First, I don't think it's plain error. I'm not conceding that. I think it's knowing and voluntary. Because we're not asking to vacate the plea. But to get exactly to your question, Judge Wynn, 95, 98% of federal criminal cases end in a guilty plea. So we have become, unfortunately, too accustomed to everything a defendant's giving up, everything the government is getting in a guilty plea. We don't get a jury. We don't get to question witnesses. We have to incriminate ourselves. We don't get to call witnesses in our favor. We lose all of those rights. Now, the government wants to make the waiver of the right to appeal a sentence so central to the agreement that it's not severable. But I would say that all of those other rights we're giving up, preventing them from having to go through the expense and the burden and the risk of loss at trial, that's what's central to the plea agreement. And like any contract, if the government felt this provision, as the drafter and tons of case laws say that we construe it, against the government as much as they're the party with all the power, they could, and maybe I'm giving them an idea, they could put a provision in there, like you see in a lot of civil contracts, this is not severable. If this falls, the entire plea goes away. I don't see any reason they couldn't do
Or they could
that.
ensure that the Rule 11 hearing is done appropriately.
That we were both there, Your Honor, and they didn't stand up and say anything, and neither did we, but
Well,
we're
it's
not the
their
party
burden to-
attempting, exactly, their burden. We're not the party attempting to enforce it. They are. And I do think it is very severable. We get up, it just has to do with the sentence. He is still guilty. He does not get a jury trial. He does not get to call witnesses. He still has to, admit his guilt. All of those core fundamental Bill of Rights protections, he loses them all. The government still doesn't have to take him to trial. This severable provision goes away. And again, this isn't a hard.
And then we take the next step, and the sentencing is procedurally unreasonable,
Yes.
and it goes back.
So it goes back for a full resentencing, not
Okay.
for a replea, for a full resentencing.
All right, let's hear from the other side. You got some time to.
Oh, yeah.
Come back.
Thank you.
Ms. Fritz?
Review. If this is going to be a referendum on the adequacy and quality of the Rule 11, which here we acknowledge was lacking in some respects.
Then why didn't the government try to ensure that a Rule 11 quality colloquy that was not lacking in some respects was accomplished at the hearing?
I take Your Honor's point, criticism, and I think both of the parties could have said or done more.
Well, it's the government's burden on the waiver, first of all, and it's the government's job to see that justice is done.
It is, and I would direct the court to the totality of the circumstances, and I think that what was known to the government at the time this guilty plea was entered. I think that you need to look not just at the Rule 11, but a lot of what comes before that. And to me, I kind of break some of the things that come before that as being the document, the defendant, and defense counsel. So we have a plea agreement that was reduced to writing. This court has indicated that it's a clear agreement. The waiver is unambiguous and plainly set forth.
Start with the person, the defendant.
The defendant was 30 years old. He attended school through the 9th grade. I
And
acknowledge.
had a .07 grade point average.
I acknowledge
And a pretty significant psychiatric diagnosis.
Yes, I acknowledge he did not do well in school, and he had a history of mental health and addiction problems. But nothing suggests that those problems prevented him from being able to understand the plea agreement or the significance of his
Because the
guilty plea.
plea colloquy wasn't thorough in that respect, other than, as I understand it, the sort of boilerplate language that we hear at the beginning of every plea hearing, your age, your education, all of that. Was there more about that?
I
Did he-
would point to one additional thing, which is specifically that the court asked defense counsel, do you have any questions about his competence? And I think that this is a seasoned, experienced criminal defense attorney who specializes in criminal defense work. It's an assistant federal public defender who has worked with this defendant, and if the defense attorney had any questions, qualms, or reservations about his ability to proceed as the parties agreed upon, it should have said so. So I think that that supports.
Can you respond to the issue about the appeal waiver being severable?
We don't believe that the appeal waiver is severable. Obviously, this court has recognized that there are benefits and virtues to the plea system, speed, economy, and finality, and the waiver language serves that. So when you have
So
a,
how far could this appeal waiver go in the government's view? So you've acknowledged that this plea colloquy was, quote, somewhat lacking. And then that the sentencing, you also acknowledged the sentencing here was procedurally unreasonable, correct?
correct.
What if this, it was even more lacking than here, just bare bones, which I think this plea colloquy was pretty bare bones. Bare bones, could at sentencing then, the court just go in and say, I sentence you to life and leave the bench? And it's clearly procedurally, it's unreasonable in every respect, but then there's the appeal waiver. Is that fine with the government? Can this district court judge start doing that?
The government would not seek to enforce the appeal waiver in that sort of circumstance, but I think that when you look at the issue that's presented here, it's a procedural reasonableness challenge to a within guideline sentence. That's certainly the type of issue that routinely falls within the scope of the appeal waiver. This court does have
Did
case.
I read in your brief somewhere that if we remand for a new resentencing, then the government would reserve the right to invalidate the plea or wanted to invalidate the plea or something like that?
If this court says that the appeal waiver, if the court says that the defendant did not knowingly and validly waive his right to appeal, I do think that that calls into question whether the remainder of the agreement was knowing and voluntary. And it's,
But we would fix that if we simply say it's severable. If we said it's a severable situation, you wouldn't have that option.
that's true.
That's true.
It is possible that the court
That was
could,
a question about whether this is a severable situation. This circuit's practice has been to treat these as severable situations. And it wouldn't be out of the ordinary to do so. I don't know if we're compelled to do it, but what you addressed there would be a question that we'll address, at least in the deciding case, if we get that far in it, past the knowing and voluntary.
I think that when I look at this court's case law in circumstances where the court has declined to enforce the appeal waiver, there was simply more information or evidence in the record showing a confusion or misunderstanding. For example, there's the Wessels case, and that was a case where the appeal waiver was never asked about, and the defense counsel represented the scope of the appeal waiver incorrectly, and that was confirmed by the judge. That's a circumstance where I think there is affirmative record-based evidence for this court to say, you didn't understand that waiver. The attorney in the court didn't understand that waiver. Similarly, in Mannigan.
Have we ever proceeded to the merits of the sentencing after determining that the appeal waiver was void? Have we ever done that?
Yes, and those are the cases that I'm,
If we have done that, then doesn't that imply that there's a severance in that context? If we proceeded on, and after it's found as void, doesn't that imply there's a severance?
it does imply that, but I would point out that, again, those were circumstances where there was affirmative information showing that there was an actual misunderstanding. Similarly, in Manigan, that's another case where the court declined to enforce the appeal waiver and proceeded to the merits of the argument. There, the court told the defendant at the Rule 11 hearing, you have the right to appeal your sentence.
Is that list exclusive with us? Were we the ones to determine that, or was that by statute, or was it required, those circumstances? In other words, could this court decide that this circumstance fits it also?
I think that I would differentiate the circumstance under the totality of the circumstances. Because again, we don't
But
have.
my point being, in the Manning, in those cases, the court made those determinations, is that right? But it's not an exclusive list, an exclusive manner in which it can be done.
The court made those determinations based on the individual record before it. Our position is that this record before you does not support reaching that same conclusion.
Fair as enough.
And I mean, again, there was no evidence of misadvice. There wasn't any conduct or responses by the defendant indicating a misunderstanding or an inability to understand.
Well, you know, when you think about it, when you have a circumstance like this where the trial judge, you conceivably just does not follow as what's there, you wonder, well, what would be the incentive if we simply just rubber stamp these things every time for the trial judge to do it? And then why even ask them to do it in the first instance? Just say, do you understand what this waiver is and what this appeal is all about? And if he says yes, just end it. And you know, what it comes to mind, I spent a lot of years as a military judge, and I promise you, you never had this problem because it was a script in front of you, and it went on. A plea colloquy could go on for like hours, and it was amazing. I never seen anything like it in my life. I'm not suggesting we go that far, but there are basic things that these sentencing provisions require, and it seems just fundamental. It's almost like if you do these things, you don't have a problem on review. But when you don't do them, this case shouldn't even be before us. All the judge had to do was pick up and read what he had to do. It's simple. And if he does that, we don't have this appeal. We don't have this kind of situation. So how do we, where does this end if we continue to do this? This is not the first time we've done this with this particular judge.
And it also encourages the continuing procedurally unreasonable sentencing that occurred here after this plea colloquy that was lacking.
I want the court to understand that we take its concerns about the adequacy of the Rule 11 seriously.
All right, sir, I think you do. I agree with you on that. But my question goes to, maybe even in your job as a prosecutor, when a judge doesn't do it, you realize this can be a problem. You bring it to the judge, Judge, we would like you to do this too. I know it's difficult, depending on the personality of the judge, to do it. But, you know, at the end of the day, trials ought to mean something. You got to take these things serious. You can't just come up here and do something slipshod and say, well, that court up there is being, you know, not being reasonable with us and they don't understand our work. We understand it, but this is very straightforward. It's not rocket science. Simply read. You got a defendant who's about to enter a plea. Make sure he understands in a knowing and voluntary fashion. Sort of list it out for you. Don't you think that's not unreasonable, is it?
I want to go back a little bit to how I appreciate that this court realizes that sometimes it's difficult to stand before a district court judge, and especially a seasoned district court judge, and say, hold on a second, judge, what about this? What about that?
You don't say, hold on, judge. You can say, Judge, there's a case here, and sentencing requires this. We respectfully would like for you to do this. It doesn't have to be, hold on, judge. That's not going to work. That's the way you do it. And if the judge chooses not to do it, then so be it. I mean, but, you know, to come to this court when you have all of these things that are available to you to do your job the right way, and come here when it's not done the right way, and then charge this court to say, well, bend over backwards and don't look at it and don't, let this go by. When you look at the totality of the circumstances, that's a phrase that can be used for a lot of things. When you use that phrase, totality of the circumstance, it's really a subjective determination, which surely we can write opinions that way all day long. It's all how you word it. But at some point in time, certain things like this that are very clear and straightforward, sometimes you have to really drive it home to get it home. Otherwise, we're going to be dealing with this over and over again,
And
which we have done.
this court, I pointed out both in the brief and in the rule and in a 28J letter that this colloquy has been deemed by this court under the totality of the circumstances to be sufficient for there to be a finding that the appeal waiver was knowing and voluntary.
That's the very point. It's been deemed that way, but notwithstanding, we know this is deficient.
After Bailey,
You agree it's deficient.
I agree that there are shortcomings,
So we deem
absolutely.
something like this, then what is the incentive to do anything other than a deficient colloquy for now? If you say we've deemed this to be sufficient, why wouldn't everybody just do it this way? Because we say it's okay.
That it was an unpublished decision, and to my knowledge, it's the first time where this court has found an appeal waiver unenforceable solely based on its discussion of the failure to strictly comply with Rule 11 B1N and other errors in the Rule 11 that were not prejudicial.
We should have published it.
And I want Your Honor to understand that when we read that opinion, we took that seriously. And I think that you will see that in plea agreements, post-dating Bailey, we now have a signature line immediately after the appeal waiver. We also have included a provision in the plea agreement to go over the advice of rights in Rule 11. So we are trying to do our part.
Okay, so then if you took it seriously in cases following Bailey, was this plea and sentencing after Bailey?
No.
Okay. But you're taking it seriously now, and you're arguing this case, and you agree that the sentencing that occurred after this plea was procedurally unreasonable, correct? The government
Correct.
agree- If you're taking it seriously, why let a procedurally unreasonable sentence stand? Why is the government not just conceding that and going back and asking for a resentencing together with the defendant if you're taking it seriously and you want to assure that justice is done? You have conceded there's a procedurally unreasonable sentence.
Yes.
Why not fix it?
And had this case been resolved on a motion to dismiss, we would have never gotten to our position on the substantive merits of the challenge. And I think that the fundamental difference between the parties is that the government believes that when you look at the totality of the circumstances, he did knowingly and voluntarily enter into this plea agreement with its appeal waiver. And those circumstances are, again, the Rule 11 does include an explicit reference to waiving your right to appeal. There's the absence.
And also, I just have to say before, your time's running out, before you sit down, I know you said that your position on remand about taking back the plea agreement is because the government would say that the whole agreement then have not been knowing and voluntary. But to say that you would withdraw the plea agreement if this case is remanded sounds like you're walking into a vindictive prosecution situation to me.
Again, I think this goes to the idea that we think that the plea agreement in its entirety was knowing and voluntary. And I want to point out that as far as I have read the defendant's briefs and also understanding the representation here, I don't understand the defendant to have ever said, I subjectively didn't understand this. I didn't know there was an appeal waiver. I didn't know I wouldn't be able to appeal my within guidelines sentence. That's important to us. Because when you look at everything else, you look at his age, his education, the fact that he is represented by competent counsel, the defense counsel at the start of the Rule 11 hearing
I
says,
think you can take his education out of that list. That doesn't help you.
well, he's able to read, write, and understand English. And I think that this court has upheld the validity of appeal waivers with individuals with even less education than him. And although he does have a history of mental health and addiction issues, he'd been in custody for 10 months by the time he was making this guilty plea.
Let me pause you for a moment. I want to ask Judge Floyd, do you have any questions?
I don't have any questions.
Judge Thacker, you have any further questions? All right, we're going to rest where we are. We'll give you just a few moments to respond. Thank you very much.
Thank you, Your Honor. We ask you to dismiss defendant's sentencing challenge.
Thank you.
Your Honor, three points, which I think I can make in under 4 minutes. So just to get to you asked a question, Judge Thacker, about, the hypothetical where the judge just says, I'm giving you life, and walks off the bench. One of the exceptions to an appeal waiver this court has recognized is manifest injustice, which I think in that hypo would apply. But what's interesting is in a case like this, because we don't know what the judge relied on, I don't think he relied on an impermissible factor like race. I don't think he relied on a factual misunderstanding of the record, but we don't know. So that's all the more reason in a failure to explain case like this one, why maybe applying an unknowing involuntary appeal waiver doesn't matter. Counsel said at no point did we say we didn't understand. Our
Yeah,
challenge
that was
here.
gonna be my question.
Our challenge here is that the plea was unknowing and involuntary. That's right in our brief. That's the challenge. Judge Wynn, I don't think it's plain error. We're saying it was unknowing and involuntary because it wasn't just not explained properly, it was sort of misexplained. He said, you waive your right to appeal your
The
conviction.
problem with the plain error, and plain error is the review you apply when there's an unpreserved Rule 11. But here, that's not the sole issue on this appeal. It's the Rule 11 objection to the evidence that the appeal waiver was not knowing. And so that voluntarily ended it too, which it's a logical antecedent type issue here.
And in Bailey, the Rule 11, I think the court said, quote, nearly a dozen errors and omissions in the Rule 11 was context for showing that this particular provision, the appeal waiver, was unknowing and involuntary. We're not asking to vacate the Rule 11, and the government has said we may move to vacate it in the district court. No one is asking this
You're
court.
asking to sever
Yes.
the waiver provision of the plea agreement?
Yes, Your Honor.
Okay.
I'm asking to say, they want to enforce it.
What's your best authority that we can do that?
Just as Judge Wynn pointed out, because this court has done it before, albeit unpublished, but in those cases, in both Bailey and Abney, the defendant did move, unlike here, to vacate the plea, and this court said no, but we're taking out the appeal waiver. So the issue was squarely in front of this court as to whether it was severable, and in both instances, the court did sever it. And I'll just close by saying, the majority of Rule 11s I've ever observed, having done this for a long time, go somewhat routine without a hitch. But every defense lawyer and prosecutor can remember those instances where a Rule 11 was done properly, and a defendant actually does say, well, wait, is that what I'm agreeing to? I didn't. I remember one.
And then the court gives them time to discuss it.
Right, and the court will say, you know
step
what?
out.
We're going to continue this to next month. Go talk to your lawyer. That's how it's supposed to work. Because if 9 times out of 10, if 49 times out of 50, a defendant understands it goes, Rule 11 is the final point. You are not sitting in a jail cell. You're not talking to your lawyer. You don't have people yelling behind you in the commissary. You are in court.
You're beginning to sound like you're making a nice jury argument, right?
Yeah, and Your Honor,
We don't listen to that very much.
And I know, Your Honor, I guess what I'm saying, and this court knows it, and I think the questions demonstrate it, these things are important, and when you waive a right, it should be knowing and voluntary, and on this record, it's not. We would ask you to reach the merits and to vacate the sentence and remand for resentencing.
All right, thank you, both counsel. We'll come down and greet counsel as it is our custom. Judge Floyd will not be able to join us, but he will be greeting you virtually. All right, we'll proceed to the second case on today's calendar, United States versus Richardson. And we're prepared to hear from defendant's counsel.
Good morning. May it please the court. I'm Michelle Ligori for Tovis Richardson. Mr. Richardson is 47 years old. He had never been convicted of a felony before he pleaded guilty in this case, so he was allowed to possess a firearm. He's now serving a 20-year sentence for 2 drug trafficking charges, which was a guideline sentence. That sentence was erroneously enhanced based on a shotgun found in the trunk of his car at a time when he was not engaged in drug trafficking.
What in this record suggests that plea agreement was not entered into knowingly and voluntarily?
We are not arguing affirmatively that the appeal waiver was not entered knowingly and voluntarily. Our argument on that point is that the government had the burden to show under the totality of the circumstances that it was, and the government just cited 2 pages in the joint appendix on that point. So
Was the Rule 11 colloquy sufficient or insufficient?
we don't have specific arguments on that, but our additional argument on the appeal waiver is that enforcing the appeal waiver as to the guideline
So
challenge.
wait, when you say you don't have specific arguments on that, are you conceding that it was sufficient? It was pretty fulsome.
Our argument is the government has the burden to show under the totality of the circumstances
But
that
answer
it was
that
knowing and
question.
voluntary. Pardon me?
You say, answer that question. You
Whether
say
we're
we are
conceding
not
it?
arguing that it's insufficient. I'm telling you right now, that's a concession under our case law. So you tell me, and I ask you the question, was the Rule 11 colloquy sufficient in this case in determining as to whether it's knowing and voluntary? And your answer is?
Our answer is we don't have an argument, we don't have a particular problem with what the magistrate judge said during the Rule 11 colloquy. But to enforce an appeal
Which
waiver.
would indicate that the plea agreement was entered into knowingly and voluntarily.
We don't necessarily disagree with that, Your Honor. It's a very specific and minor point that we were making on that issue in the brief. The bigger point on the appeal
You
waiver.
have a plea agreement which is knowingly and voluntarily, it's enforceable. So what is your issue?
The main issue in terms of the enforceability of the appeal waiver is that enforcing it to bar correction of the guideline error here would sweep in something that's not covered by the appeal waiver.
How do you appeal it?
Pardon me?
How do you appeal it?
I'm not sure I
I
understand
mean,
the court's
how do you
question.
appeal something if you've waived the appeal? You waived the appeal. You just said the appeal waiver is good. And the appeal waiver covers this subject. So how do you
Well, we
appeal
have
it?
two points. We're raising an ineffective assistance claim, which is not covered by the appeal waiver. But appeal waivers, sometimes even if they're knowingly and voluntarily entered, it may be unenforceable
Ineffective
anyway.
assistant counsel, I can see that on direct appeal, but what
But
else are
we're
you
we're
appealing?
contending it would be a miscarriage of justice to enforce the appeal waiver here. Because
But
enforcing,
the exception for a miscarriage of justice, why would that apply in this case?
because enforcing, affirming the guideline, not barring correction of the guideline error here would mean that Mr. Richardson would not be eligible for relief under Amendment 821. So that provides a 2-point reduction for defendants who have no scorable criminal history, but there are exceptions. So in one of those exceptions is if the defendant possessed a weapon during the offense. And so if there's an erroneous finding that Mr. Richardson possessed a weapon during the offense, which we strongly contend there is here, then Mr. Richardson is not eligible to seek, well, he would not be able to get relief under Amendment 821. And that is not something that he waived in his appeal waiver. That's not within the scope of the appeal waiver, and typically defendants who pled guilty and have appeal waivers, they can still seek relief under Amendment 821.
So you chose to bring it on direct appeal instead of waiting on the 2255 proceeding, the ineffective assistance counsel.
We have the argument here, so we brought it in this case, and we believe that the record shows that ineffective.
Assistance of counsel argument.
Well, this court has said that counsel has an obligation when confronted with error during a judicial proceeding, to object contemporaneously, calling the question to the court's attention and preserving the issue for appellate review. And the court said that in the Carthorne case. And here there was a very strong argument at a minimum that the dangerous weapon enhancement was erroneous. The only thing that the enhancement is based on is the fact that a shotgun was found in the trunk of Mr. Richardson's car on October 8th. And that day, Mr. Richardson had been subject to a traffic stop, and there's no indication that he was engaged in drug trafficking at that time. No
But
drugs.
isn't our case law pretty broad on when this gun enhancement can be applied in relation to drug trafficking? In particular, Bolton, where it was applied 2 years after the drug trafficking had occurred, when the gun was located? Case law, when we have a lot of case law on this gun enhancement, that is, can be interpreted broadly in terms of time and space when the gun was found, then how could counsel have been conclusively ineffective in not objecting to that?
Well, the case law does require that there's a connection between the firearm and the offense conduct. And that's true in every case. Sometimes there's more of a connection than others, but in every case, there has to be a connection. And the McAllister case is very important, and it shows that you can't speculate to find a connection. There has to be evidence.
We're talking about the drugs, and then a gun is found in the car. Is that what we're solely talking about here?
Yes, yes.
So when you're looking at, to the extent we can look at the application notes in the sentencing guidelines, there seems to be a pretty clear example right there. You familiar with that example in the application notes?
If the court might remind me of that example.
Well, I don't know how you could miss it. It says, for example, the enhancement would not be applied to the defendant arrested at defendant's residence had an unloaded rifle being found in his closet.
Right, and this court has said that in its
How you
case
miss
law
that?
as well.
I mean,
No, I
you
didn't,
got
I did
a
see it.
drug
Your Honor, I apologize.
situation, and you got a gun found in the trunk of a
Right.
car. I mean, how in the world can you miss this note? If
Well,
it
Your
has
Honor,
any applicability at all.
We believe-
in determining your question of whether a counsel ought to know that an enhancement that significantly increases this sentence might not be something that should be applied here. That note there is
yes.
almost spot on.
Right, we do think that note is very important here, and that it shows that there has to be a connection. You can't just be the defendant possesses a weapon and he's a drug trafficker. There has to be more. It has to be that the firearm is present during the offense conduct. And this case is very similar to the situation in the note, and that this court has discussed in its case law, because we have drugs in the home and the firearm in the trunk of a car. And the firearm is not present with the drugs on October 8th, and we have no evidence in the record that the firearm was ever present with
Or
drugs.
that it was loaded?
We don't have evidence that it was loaded, that's true. And so the only way to make a finding here that there was a connection between the firearms and the drugs would be to speculate. And McAllister is very clear that you can't speculate. And the government points out in its brief, it says, well, Mr. Richardson had several transactions in his car, and that's discussed in the PSI. It discusses transactions that occurred in his vehicle. Some of them explicitly say in the passenger compartment of the vehicle. Some of them say one of the individuals went into the car, and so I think we can conclude that all of those occurred in the passenger compartment of the vehicle. And the government seems to conclude that the firearm was in the trunk on those days, but there's no evidence that that was the case. We would have to speculate to reach the conclusion that the firearm was there during any of those transactions. So all we have is the firearm in the trunk on October 8th and drugs in the home on October 8th. There's no connection between the shotgun and the drug trafficking. And under those circumstances, we do contend that it's plain error to apply the enhancement, and that it was objectively unreasonable for counsel not to raise that objection.
All right, Judge Floyd, do you have any questions?
No, sir.
Just a second. All right, thank you.
Thank you,
We'll
Your
hear
Honor.
back from you on rebuttal. We'll hear from the government's counsel, Mr. Pugh.
Thank you, Judge Nguyen. May it please the court. I'd like to begin with the ineffective assistance claim, because in this case, there was a fulsome waiver that spanned about 11 pages of the transcript. This ineffective assistance claim is being brought on direct appeal, which requires it to be conclusively apparent from the existing record the defense counsel was ineffective. And this goes hand in hand with Strickland, which, when it comes to a strategic decision, requires a strong presumption that counsel's behavior falls within, their decision falls within a wide range of reasonable professional assistance. And
How do we, the application notes, the example I just gave you right there, admittedly, it's hard to say that does not apply on point. I get it in terms of looking at Strickland in terms of deficient performance on part of counsel. But that's right there, and it's hard to not put that example in direct comparison with what went on here. How do we, first of all, answer the first question. How do we view these application notes as a court? Or do we?
I would view the application note as one potential data point, one suggestion that there are circumstances where the gun enhancement should not apply.
Well, you know, this court, we've been round and round on the sentencing guidelines in terms of how they are to be used, you know, whether or not they're plain, and then we get to the application notes, their problems and things like that. And that's where I'm getting to is, you know, to what extent we informed, and should counsel be informed, when you read that example right there, even if you don't win it, who in the world would not object if you have drugs in the house and then out in the trunk of the car is a gun, and it's not a handgun, is it a hunting gun? They say
It's a shotgun, Judge
They call
Nguyen.
it a shotgun. What's the difference between a shotgun and a hunting gun?
I suppose that you could use a shotgun to hunt birds and things. The example from the guidelines specifically mentions a hunting rifle.
Right.
So I think rifle, single shot, long distance, and there is case law talking about how a shotgun, even a shotgun, it might not be a pistol, maybe that's the number one preferred
Right.
weapon, but shotguns themselves, let's see, Kimbrough, Sixth Circuit, 2010, a shotgun is, quote, of a type associated with drug trafficking. In our response, we cited U.S. v. White. While a shotgun may be used for hunting or dispatching animals, it is also effective in threatening, injuring, or killing human beings.
When do you characterize it as a hunting rifle? Hunting rifles sound more endearing than shotgun, at least from my perspective. You know, it calls something a shotgun. It sounds like it's used for something other than hunting. But hunting rifle, particularly this time of year when we like to be out doing some hunting, that sounds like, well, what's wrong with that?
Well, Judge Nguyen, I think there is a distinction between a rifle and a shotgun. Rifle.
And is there any evidence in this record as to whether this gun was hunting or a shotgun? I don't want you to get into something that's not in the record.
It specifically says shotgun,
Shotgun, no more.
as opposed to a rifle.
But a
And I-
shotgun could be a rifle, it could be a hunting, used for hunting or not.
I think a shotgun could be used for hunting, however, a shotgun is not a rifle, and I think there is a very big difference between a shotgun in the back of a car that's used for a drug deal versus a rifle that is in a closet. And an important part of that application
Use
note.
For the drug deal is something you added into it. We just know there's a shotgun in there.
We know that it's in the car that was used during the drug deal, and we also know that
During what drug deal?
the car was used during two drug
So
deals.
the car was used during a drug deal, but not, you don't know that the gun was in the car during the drug deal, because it was, do you? Do you know that the gun was?
We do not know 100%, but this court has expansively applied this enhancement and has noted that inferences are permissible.
What's the deal
That's
in
from
drug-
Mannequin.
How did the drug deals that we're aware of go down? Somebody got in the passenger seat with him or handed it out the window?
I believe that's correct.
So he wasn't dealing
Passenger
drugs
seat.
out of the trunk of the car?
No, he was not, but he could step to the trunk of the car. And I'd note, so there's two components here. There's was it connected and what's the time frame? Regarding the time frame, I would highlight that this is a conspiracy that ran from October 2020 to October 14th, 2021, encompassing the day that this shotgun was recovered from the trunk of the car. And we know that during the conspiracy,
Was
there
it
were...
loaded?
That is not on the record.
Do you know if it was loaded or not? Does the government know
Reviewing
if
the
it was-
discovery below, it was unclear. I do want to make one clarification. We mentioned that there were 3 transactions that used the car where the shotgun was found. In reviewing the record, we saw that he used actually 2 cars for transactions, and we confirmed that the first and the third of those transactions was definitely the same car with the shotgun. The second one we could not determine.
You keep saying the same car with the shotgun, but we don't know if the shotgun was in the car at the time
When I
of the
say
drug
that, I'm referring to the
transactions, correct?
car-
Wait, let me finish. You
Sorry.
don't know that the shotgun was in the trunk of the car at the time of the drug transactions, correct?
That is correct.
Okay, now what did you want to say?
The second of those transactions that was with the car where the shotgun was later found was October 1st, 2021. This search that found the shotgun in the car during the conspiracy period was October 8th, so it was merely a week. We also know that he obtained the shotgun from his father, who died in 2012, so there's a strong inference that he had it throughout the conspiracy period.
So revisit the review here, that we reverse only if it is conclusively appears in the trial record that the defendant was not provided effective representation. Is there more to that? Because that seems to be a difference than if the defendant conclusively shows that he was entitled to this particular right. Here we've been going back and forth, but we do have a real question as to whether that gun, even if it's not conclusive that the gun, but that's not what's necessary. Conclusive is whether it was deficient representation, that a counsel would have some strategic reason to not go forward with this, seeing this application note, and knowing that gun is in the trunk, drugs are found in the house. Isn't that the standard? I mean, when we're talking about the standard, it seems like it fits. It depends on what you view as being conclusive, because we seem to be talking about conclusive is, well, it's conclusive that this court would find that that's gun should not have been included. And is that necessary, or is it that it really seems well beyond the preponderance or well beyond, question that you would at least question that? A reasonable counsel, and I can't think of a strategic reason a counsel wouldn't do it.
Judge, I can offer you several, but first I want to state that it's our position that even if there were plain error, and this court said this in Carthone, even if there is plain error, that does not mean there is ineffective assistance. So we dispute this idea that there's no evidence. There's a gun found in a car, and this car is an instrument of the conspiracy. This court has multiple cases that have applied this very broadly in those circumstances. But nonetheless, there's any number of reasons that counsel may have strategically made this decision. And I'll highlight a few things that are not on the record for the court. We have not had an opportunity to see what went into this agreement for 240-month sentence between defense counsel and the government. Were there phone calls, emails, even a meeting where they pled that case? It's very presumptuous to say that that was not a good result, and we don't know what went into that. We don't know what other...
We don't know what it would be without enhancement, though. Without that enhancement, it wouldn't be 240 months.
Correct.
And that's really the question before us, and not whether there was some, maybe what you're saying to us is this is something we ought to allow the trial court to develop? Is there
Yes.
additional evidence of this, rather than to do something here, a reversal? Is that what you're saying?
That is exactly the point, and that's why this conclusively appears standard is used in these. It's why these appeals that recognize ineffective assistance on direct appeal are very rare, because we do not know why counsel made the decision they made. And if we compare it
Is
to,
it correct that prior to this conviction, he wasn't prohibited, a prohibited person from having a firearm?
that is my understanding.
Okay, now go ahead.
If we compare this to the cases where the court did recognize on direct appeal ineffective assistance, there's a stark difference. Freeman, most notably, Sturdivant is another case that recognized ineffective assistance on direct appeal. There, it was a discrete, purely legal issue, in the court's words, could not be more pellucid and applicable.
So you're saying the record is not as developed as it was in Freeman and Sturdivant, and that if we do take some corrective action here, some action here, we should simply send it back to the trial judge to allow you to develop the evidence in this case?
Well, the proper avenue here would be a habeas proceeding to figure out exactly why defense counsel did what he did, because the record,
It's still available.
yeah, in the future, that is exactly how this should be decided. A habeas petition if the defendant wanted to pursue that. Because the record here is silent, and that is in stark contrast to those cases, and Fisher is the third one I found.
So even before the habeas, you're not saying that you're not saying it would be improper for us now on direct appeal, because it is before us, and the record is pretty stark. You say not as clear as it is in Freeman, for us to send it back to the trial court and say, hey, let us, develop the record on this as to whether there's some other evidence on it outside of this record.
But my belief is the proper avenue for that is a separate habeas proceeding, post-conviction. That's how this plays out. This is how Sturdivant says those unanswered questions about why counsel did what they did are answered. Judge Wynn, you mentioned the guideline range potentially being different. One of the other aspects, and this is on the record, is that probation stated they did not believe that acceptance of responsibility was appropriate because of these positive drug tests that occurred. And defense counsel brought this up at JA 94. He said, Judge, we understand that this was stated by probation. That would have raised the guideline range significantly. There could have been other potential enhancements that defense counsel successfully avoided. There often in cases are obstruction enhancements, potential leadership enhancements. We don't know the full playing field here of potential sentencings. We also don't know if there were any discussions.
There was a letter, some pro se letter that was written by the defendant, and this is striking language. He said he asked his lawyers, why you pay him $25,000 if I'm gonna get 20 years in prison? And the lawyers told him that they paid the money to be a year and a half out before sentence. Sounds like to me, I don't see any strategy in terms of that 20 years there in that. And he basically told him he'd rather be doing the time now, with doing that year and a half, rather than waiting and now doing 20 years. So it looks like the lawyer's focus was, how long can we keep him out of jail for $25,000? Not, how much time less he could get. His focus is the period of time he's gonna spend in jail. And apparently from this letter, they're saying, no, we kept you out of jail a year and a half. We gave you a year and a half of freedom when you could have been in jail. And he said, no, I wish I'd been in jail. I'd be a year and a half into my sentence.
Well, one of the
To the extent that goes to deficient performance, at least when we're talking about how the lawyers perform, that seems to be some evidence here. They weren't interested in the 20 years.
and Strickland advises us that deference is to avoid looking back in hindsight. And in the same letter, he stated, actually, I didn't want to plead guilty. Actually, I didn't want to be released. He didn't like anything that happened, and I'd submit that there was a lot of hindsight in that letter. I would also like to highlight, we don't know from the record, as it's currently developed, whether there were emails, phone calls, meetings about specifically this enhancement. And it's an important stricture of Strickland that if there is a thorough investigation, it's virtually unchallengeable, and the record, as it's currently developed, does not show one way or the other. And lastly, we don't know what other discovery is available as to this objection, as to this potential objection in the firearm enhancement. What other information might have been in discovery or might have been known to defense counsel from the defendant. Given that it was not objected to, defense counsel has an interest in keeping out any additional unfavorable evidence. And there's no guarantee that what's in the PSR is all that was known regarding this enhancement. I do want to highlight one case regarding the enhancement, though, and I think it's very similar to what we're looking at here, and that is the Manigan case. In the Manigan case, for this court 2010 decision, there were 2 drug deals in front of Manigan's house that led to a search warrant the next month. During the search warrant, they found 2 handguns. They didn't know if it was loaded or not. It wasn't on the record, like this case, in the back bedroom and a shoebox. The evidence had only shown that a month before, there were these drug deals in the front yard. This court nonetheless recognized that the house was central to the common scheme or plan, and that the evidence circumstantially supported that those firearms were there and available to the defendant, and even that they were readily accessible. Even though you have to walk into the house to retrieve them, they were readily accessible. Here, instead of firearms in a back bedroom inside, we have a shotgun that's mere feet away by inference from the defendant during drug deals. And I think the inference is very strong that these were present, or at the very least, it was in the car.
Mere feet away, but he had to get out of the car and go around and open the trunk and.
Which I believe compares favorably to Manigan having to walk into the house to the back of a bedroom.
Doesn't Manigan didn't it also say an unloaded hunting rifle is a firearm that would not be readily connected to drug activities?
Yeah, yes, it did. And
Back in that venue.
Yeah.
and in U.S. versus White, it was a Ninth Circuit case, but they rejected the idea that a shotgun was functionally equivalent to an unloaded hunting gun. And I do want to highlight that in that guideline note, it mentions they go to arrest him and find the unloading hunting rifle. So there's no talk about drugs being present. If that unloaded rifle was sitting there with a very large bag of heroin, I'd submit that'd be a dramatically different case.
Okay, you have anything further you'd like to add?
Yes, Your Honor. I would also like to point out this court's case in U.S. versus Apple regarding the firearm enhancement. In Apple, there were drug deals in an apartment, and the defendant contended that a gun that was later found during a search warrant in the apartment was no evidence of nexus, that it was related. And this court stated that stated it's clear under the guidelines that when the offense committed is conspiracy, these proximity conditions are met when the weapon is discovered in a place where the conspiracy was carried out or furthered. And this court cited to United States versus Rush, a Seventh Circuit case that said the enhancement based on the weapon found in the car that was, or applied the enhancement to a weapon that was found in a car that was essential tool of the conspiracy. And we know that the car is an essential tool of the conspiracy, and that's where the gun was found 1 week after a deal and still within the conspiracy period. And I'd point out also, there's only one place that the record shows that this gun would likely be, if not in the car, and that's in the home, and that's where the 4,000 pills of methamphetamine found. And I think that is a very fair and strong inference, because also found in the home are this ammunition of various caliber and gauge that the defendant admitted came from his father at the same time. He said, I got the shotgun and the various gauge and caliber ammunition from my father. The only places associated with his firearm are the car, it was a tool of the conspiracy, and the home where all of the drugs were found during the conspiracy. And lastly, I'd point out.
Did the ammunition match the gun that was located in the trunk?
The PSR does not specify, but it says various caliber and gauge.
So you don't know that either?
I think it can be inferred, but we do not know it 100% from the record that's available. The discovery below shows that it was, but the record does not show. But given that it was from the father, and it specifically says it's gauged ammo, which would fit in a shotgun, I think it's a clear inference. We'd ask that the court uphold the appellate waiver and decline to recognize ineffective assistance on direct appeal on these facts. Thank you.
All right. Thank you very much, Mr. Pugh. Ms. LaCory, you have just a few minutes.
Thank you, Your Honors. Regarding Judge Wynn's question about what needs to be conclusive for an ineffective assistance claim, it doesn't need to be conclusive that there was an error. And that's clear from the Freeman case, where the court said there was a very strong argument that the drug quantity calculation was incorrect. But it was conclusive that counsel was ineffective for not raising that objection at sentencing. And here it is conclusive on the record that counsel was ineffective for not raising this objection. There's no need for more evidence, or there's no need to know what counsel's subjective thinking was about the objection, because the decision not to raise it was objectively unreasonable. And this court has come to similar conclusions in other cases. In one case that we cited in our supplemental authority, the Winbush case, it was a habeas case, but the court didn't take evidence on counsel's subjective reasons. It concluded that the career offender enhancement there was erroneous, that there was a good objection to it. Counsel didn't raise it, and the court found ineffective assistance and granted the defendant relief there. And it's a similar situation here. The fact that counsel asks for a 240-month sentence supports the conclusion that there was that the decision not to raise the enhancement objection is objectionably unreasonable, because that was an upward variance from the guideline range. It would be a different situation if there were some agreement to recommend a sentence that was in the guideline range without the enhancement. But the fact that there's a recommendation for a sentence above the guideline range, it shows that there wasn't an objectively reasonable decision. There are a few other things in the record that undercut that there was any sort of discussion between the parties about this objection. One is there were stipulations to guideline enhancements, and those were in the plea agreement. There was a stipulation to the maintaining a dwelling enhancement. There was a stipulation on the drug quantity. There was not a stipulation on this weapon enhancement. And also, counsel never raised the objection during the pre-sentencing process to have that as something to negotiate about at sentencing. And I would just like to address the Manigan case, and there are significant differences between that case and this case. One is that Manigan had a handgun, and this court discussed that a lot in its opinion there. It said handguns are the tool of the trade of drug traffickers. The handgun was in Mr. Manigan's home, and the court says that if a drug trafficker has a handgun in the home, you can infer that the drug trafficker was using that as part of his drug trafficking activity. It's a different story where you have a firearm in the trunk of a car and you have drugs in the home. And also in Manigan, everything was found on the same day. So there's a firearm in his home, there's drugs in his car, and he has drugs and money on his person. And so there's not a temporal difference there. There's evidence that he was engaged in drug trafficking on that day. He has a firearm in his home on that day. And so Manigan is very different from this case. It does not show that there wasn't plain error here, and it certainly doesn't show that counsel had a good reason for not raising the objection. And because the record conclusively shows that Mr. Richardson received ineffective assistance of counsel, or because there was plain error and because enforcing the appeal waiver would be a miscarriage of justice, we're asking the court to vacate Mr. Richardson's sentence. Thank you.
Thank you very much, Ms. LaCory. We recognize that you are court-appointed this case. This court could not, would have a very difficult time handling cases like this without lawyers who agree to be appointed on this case. And you've done a commendable job, as have you, Mr. Pugh, in representing the government, and we thank you for that. Judge Floyd, would you like for us to take a small recess, or are you prepared to move to the next case?
Can we just have a short recess, please?
At your wish, my friend.
Thank you.
This court will come down and greet counsel briefly, and we will take a short wait until our colleague Judge Floyd is back in session with us.
Yeah, I'm back, Judge Wynn.
All right, Judge Floyd, we are constituted back as a court and prepared to proceed to the third case of the day, the Fishers Association versus Atlantic States case. And we will hear from the appellate's counsel. Is it Butera?
Good morning, Your Honors. May it please the court. Yes, my name is James Butera, and this is Mr. Meehan, who is the co-counsel for the appellants in this case. Correctly identified as a constitutional case, and we will be advancing 2 points before the court this morning with respect to that. One, that the regulation which is in contest here at this proceeding is unconstitutional, and as well, the organization promulgating the regulation, Atlantic Commission, is in itself unconstitutionally structured at this time for reasons which, we will explain, and I'm sure in our brief.
So why didn't you sue Maryland instead of this compact?
Because the regulation in case here is promulgated by the commission, Your Honor.
But the regulation came from Maryland. They only recommended to Maryland. Well, fundamentally, let's go back to the basics. You got a compact of the various states. The compact itself then makes a recommendation. The legislature of that state acted. Maryland actually objected to it, didn't want to do it, but it didn't appeal its objection to this amendment. And as a result of that, Maryland enacted the regulation. So why didn't you sue Maryland?
Because the action by Maryland is coerced and must be implemented, Your Honor, because the legislation in 1984 changed the entire constitution, construction rather, of the commission. It went and said it from a federal standpoint, and I'll read it from here. It says, "The commission shall prepare and adopt."
Maryland can leave that compact. It's not coerced to stay in that compact.
But if they leave the compact and are thus not in conformance with the regulation, then another regulatory power of this commission is to report that to the Secretary of Commerce that they are in noncompliance, which can result in complete ban of fishing in the Chesapeake Bay and all the other tributaries in which the Maryland fishermen may proceed. So I don't think there's any question here.
I see where you're going with it in terms of, it sounds like in terms of a practical, but we're dealing with the issue of standing. Standing is a legal question. And that's what, it doesn't just apply what it looks like or what it sounds like. It's a legal question. And so when you think about it, if Maryland had not actually enacted or brought forth this regulation to its legislature, could this pact have sanctioned you?
Could it sanction?
You, your client.
Oh, our client.
Not you. Right? Not you, oh Lord.
I'm sorry, Your Honor. Yes, they could, because they could
How?
take advantage of the Magnuson-Stevens Act, which allows for penalties enforced by the Coast Guard to anybody violating a regulation. Absolutely, Your Honor.
That's not,
Let
that's
me,
not the
let
Coast
me
Guard.
ask you this question. It seems to me on this constitutional issue, you raised it for the first time on appeal. Is that right?
No, Your Honor, we had raised it from the very start, that it's a constitutional issue, because of course it's a Fifth Amendment taking, which starts with that. And then we also raised it from a constitutional standpoint that.
No, I'm talking about the framework of the compact.
On the commandeering angle, you asked?
Framework of the compact. It seems to me that you raised that issue for the first time on appeal. I understand it's Fifth Amendment taking case, but as to the framework,
No,
raise that early in the case or for the first time on appeal.
no, and perhaps this will help explain. We respectfully disagree with you there, Your Honor. So this was in 1942 that this commission was established, and it was completely advisory in that connection, as are the two other interstate compacts here that we have in the United States. But in 1984, what happened was that they mandated the section that I just read, which put enforcement powers into the commission. Now, with respect again, Judge Wynn, to your point, the Supreme Court has said in Bennett versus Speer that it does not matter whether the injury complained of has an independent third-party action, in your case, the state of Maryland. That does not exclude injury produced by the determinative or coercive effect upon the application of another person, which is the commission
Judge
in
Floyd's
this case.
question is whether, did you raise this below? Is this the first time this constitutional issue been raised on appeal?
No, sir. No,
Well,
Did
sir.
you raise it before or did not?
Tell me where in your complaint that you challenged the constitutionality of the commission or its structure. Is that in your complaint? I can't find it. I might be half blind. I don't know.
What was the sentence that you first said? I apologize for my hearing. The first part that you said was omitted?
My question was, I can't find in your complaint that you challenged the constitutionality of the commission or its structure. Did you do that in your
Yes.
complaint?
Yes, we do, Your Honor, because,
Where is it in your complaint?
well, it's where the point where we say the commission was established in 42.
Well, do you
The
have
commission-
your complaint in front of you? Because we do. Maybe you could point us to a JA site where you raise in your complaint that the commission is unconstitutionally established.
I do not have it, Your Honor, I don't think we do, but what happened was in 1942, it was founded.
You would
In
have maybe
19,
at your desk that when you come back, I think you got some time to come back. Why don't you look at it and
I will do
point
that,
to
Your
us
Honor.
in the Constitution, in your
Yeah.
complaint, what that allegation is.
But part of our constitutional issue clearly raised in the complaint is that when this commission was established in 1942, it was ratified by the Congress. When it was changed in 1950, it was again ratified by the Congress. But then in 1984, when the entire enforcement portion of this issue was placed, that was never ratified by the Congress. And our constitutional question goes to this. The United States Congress does not have the ability to alter a compact between the states. It can ratify it, it can decline to ratify it, but it is not allowed to pass a law. And this does get to the commandeering aspect of our case. It is not allowed to tell the states that they must enforce the law. The theory behind that is when party and the last party to do a regulation, but all the enforcement and the power itself comes from the federal government. Let me just read, if I may, from the executive director of the commission. He said before the Congress in 1950, the commission gave the authority to, the Congress gave the commission the authority to require states to implement mandatory provisions which the states must follow. Everybody agrees with that. The Attorney General of the state of North Carolina said, the Atlantic Coastal Act enacted by the Congress expanded the ASMFC power to make its decisions binding on the states without, Your Honor, the consent of the states. So the force behind this exercise is entirely the federal mandate onto the commission, and then finally you have the state of Maryland, which just adopts the regulation to their
Right,
state
they've
in
adopted the
conformity.
regulations. So do you have any indication that Maryland would change course and even if this amendment were enjoined? Do you have any indication?
No,
that-
no, in fact, they've told us quite to the contrary. We
Okay,
asked them
so
to.
there, then how do you have standing? How can in joining this addendum redress any injury to you if Maryland has told you they're not going to change course?
Because they will have to. That will be required by law.
No, that's, all you're asking us to do right now is is to grant a preliminary injunction. We're not reaching, I don't think. What are you asking
Well,
us?
perhaps this is the best way to explain it. Not only.
Aren't we here on the denial of your motion for an injunction?
Yes,
Okay, so we're not reaching the merits today.
I understand, Your Honor.
So how is, even if we agreed with you and enjoined this addendum, how does that help you? Because Maryland's not going to change course.
But Maryland said to us, we're not going to help you in this regard. We have a letter from the Attorney General's office because we are afraid there will be a complete moratorium on striped bass fishing in the Chesapeake Bay. Now, if that were to be removed, then Maryland, by logic and their prior behavior, would presumably go back to the position where they say, we do not want to be enforcing this because, as Mr.
Oh,
Louis.
you're saying that somewhere down the road, presumably Maryland may go back to saying they don't want this regulation, even though 2 minutes ago you said that they conclusively told you they're going to stick with it.
No, they just said that they would not appear in the case that was pending below when
Yes,
the
they would
trial
have
judge.
if you had brought them into it, which goes to Judge Wynn's very first question. Why didn't you sue Maryland?
Well, because both parties are in the chain of causation here.
And what's the irreparable harm to your client?
The effect of this regulation was to drive their business down 70%. And we said that in our complaint. At that point, we thought it would be 50, but it turned out to be much worse. By the time we filed our documents, it was at 70%.
Isn't
So our-
this regulation intended to save and preserve the striped bass?
That certainly is the purported purpose. Yes,
Right.
Your Honor, it is.
So
But-
if they weren't, if you take that at face value, without this, then the striped bass could become extinct and your client would lose 100% of its business. Wouldn't that be
Well-
worse?
No, theoretically, of course, what you're saying is true, but that presumes on the merits that the remedy at hand here is first justified and second would be effective. And let me say this, and perhaps that will help. This is the commission document, and it says, striped bass is not experiencing overfishing. This is a critical point for the very question that you raised, Your Honor. If the striped bass are not subject to overfishing, then how can this regulation, which was prepared and adopted by the commission pursuant to federal law, so if overfishing is not the problem, how can a regulation which further limits fishing make any sense?
Regulation is actually from the state of Maryland. The commission made the determination to indicate to Maryland to proceed in this matter. Maryland could choose to do so. Maybe it was coerced or whatever, but it did it independent with the legislature, notwithstanding it didn't want to. So the regulation's from Maryland.
Well, I agree with you on the final step, but again, looking to the Attorney General's opinion in North Carolina, which is, I think, shared widely, the act expanded the commission's power to make its decisions binding on the states and defining without their consent. I mean, I don't know how that could be more mandatory. And so Maryland is just.
So you are challenging the constitutionality of this, and are you doing it via section 1983?
We're doing it of all the above.
Tell me-
Yes,
tell
we
me
do
that
believe in
it doesn't have
1983.
an enforcement provision in it. So you, in order to be able to take a constitutional challenge, you gotta have a vehicle to do it. You can't come under the APA is not available. The
No,
Second Circuit made that clear.
we are
So the vehicle, it seems like I think you articulated is section 1983.
And we did assert that in our complaint. And
Well, I'm granting that, but I just want to get agreement. That's what you're going under, section 1983.
among others, Your Honor, we feel that
Tell
as
me what the among others is.
United
That you
States
can sue
Constitution.
for a constitutional
what did-
violation other than section
well, what-
1983.
Well, we would point to Marbury versus Madison, Your Honor. That says that where there has been a harm, everyone in the United States is entitled to a remedy in court. And as far as the comment about the APA, we would say that the APA is not the source of our due process and constitutional objections.
Tell me, let's talk about section 1983. How is it that this compact is a person under section 1983?
Yes. Well, I'm glad you asked that question, because as we know, states are not considered to be persons, but this is not a state, Your Honor. This is not even a collection of states. This is an interstate compact, which in 1942, when the Congress ratified it, defined it as a body corporate, not a body politic, but a body corporate. And so we believe that they are clearly acting under color of law, color of state law. So I think on this question of who regulates whom, it's pretty clear. And in fact, I wanted to point out, here is Fourth Circuit case, U.S. v.
I want to give you
Saunders.
a chance to further develop the thought you just brought up, that it is a person because it's, I guess, a compact or something different.
Right,
But
sir.
I don't know of a case that has held that. In fact, the cases, there was a Washington area Metropolitan Transit Authority, they said that's not a person, sort of like a governmental situation. And you gotta be a person in order to be able to sue under section 1983. So tell me, do you have a case?
I would
You got a case when you come
No,
back and tell me
no,
what
Your
that
Honor,
case
we're
is?
here really on a case of first impression. The one that you just mentioned was an employment case. There's another one with respect to a government contract. But here, we are talking about,
So you're saying
individuals.
it's a question of first impression?
it
for us
is,
as a
we
court.
believe it is, Your
You want
Honor.
us to independently determine that this compact is a person under section
Well,
1983?
We would argue that, Your Honor, but I want to say again that that is not the sole reliance of why we are here before the court today. We are here before the court today not on the basis of Section 1983, not on the basis of the APA, but on the Bill of Rights.
Bill of Rights and Marbury versus Madison.
Is
You
Mar-
use that too.
It is, well, that, yes, it followed in 1803 right upon it. And nowhere in the 231 years since Marbury versus Madison was decided does somebody say, well, you have to go check with your attorney general to come before the court. That's the position that we are taking. And Your Honor, to go back to your question, I mean, it's so dramatic here. We do a lot of regulation for industries at the federal and state level. But this one is very different because we were never projecting the irreparable harm, as often is the case when you're looking at a regulation, but
Mr.
it's
Butero,
90 days
Mr.
effective.
Mr. Butero,
Here,
Mr. Butero, we've given you some extra time. What we'll do is, let's
Ooh.
hear from the other side, and we'll
I see
come
that.
back and hear you on the rebuttal. How's that?
appreciate that, Your Honor, I missed that. Thank you.
Mr. Donahue?
May it please the court. Sean Donahue for the Appalachee Atlantic States Marine Fisheries Commission, and with me at council table is my colleague Carrie Davidson, and behind her is Robert Beal, who's the executive director of the commission. The district court did not abuse its discretion in denying a preliminary injunction in this case. As the court noted, there are.
Address the issue of standing.
Yes, as the court noted, this was a Maryland regulation that actually is what affects what fishers can do. And there are reasons. We would concede that Maryland adopted the particular one fish bag limit in response to the commission's plan.
They
But
coerced into it? Mr.
We-
Butero said they were coerced into it.
I don't think it's fair to think of anything in this regime as coercion. As the court noted, as you noted, Judge Wynn, the member states all continue to be voluntarily associated with this compact that they entered into decades ago. Any state can drop out, and contrary to what my friend said, if a state actually withdrew from the compact, that has not happened before, but it would no longer be subject to this regime. It would lead to a very different one, and it would not be subject to the requirement that it follow the commission's plan. So that's not what we have. We submit that the real standing problem here is redressability, because there is reason to think that Maryland would not rescind this regulation. As we noted in our brief, Maryland actually adopted additional measures, including
And I
cancel.
thought I heard a opposing counsel confirm that Maryland has said they won't reverse course.
Yes, I'm not aware of any sign that they have said that they would, and I think the fact that Maryland didn't take advantage of the internal commission appeal process, it also would have the right to bring its own action in court to challenge the plan. And then there is just a conservation problem here, contrary to what my friends assert.
Yeah, well, I don't know what, I was going to ask you about that. I'm not sure what he was reading from when he said the striped bass are not subject to overfishing,
Right.
because I'm reading the record.
Yes, he's referring to a nettlesome sort of terminological sort of issue, and that is the distinction between overfishing, which is removing fish from the stock at a rate that is unsustainable and driving the numbers down further, versus overfished. And the commission has found, and other scientists have repeatedly found, that the stock remains overfished. That is, the biomass, the total number of fish out there is well below what it should be. And the commission is in a process of trying to rebuild the stock to the healthy level that it was before. And of course, as the court is aware, this stock, which is so important up and down the Atlantic coast for recreation, for sort of it's embedded in the culture of many states, it collapsed severely in the 80s. And as you see in the record here, there are knowledgeable, scientifically well-grounded people who are worried about the signals that particularly recruitment of the younger fish into the fishery that can be caught. It has been low, not just for 1 year, but for many years. And that's something that's been, is clear in the record. And that's what the commission is attempting to deal with here. If I may, I would like to point out that the very broad constitutional claim that was asserted here, that the commission itself is unconstitutional, it's structurally invalid. And I think the implication would be that this interstate entity that has been successfully operating for many decades, sort of everything it does is in question. We think.
Let me make sure I posture this case where we are.
Yeah.
The first question I think we deal with is the question of standing.
Yes,
We decide there's no standing, that's the end of this. Is that right?
I think so,
We
Your Honor.
decide there is
Yes.
standing, then we address the constitutional issues, the issues being due process, a takings clause. And then
Right. Those are the ones that were raised below.
A constitutional challenge in terms of the
A highly consequential claim. We disagree with it strongly, but I don't think it would be appropriate to reach that in a PI review
what
where it
about the
wasn't
takings
raised.
clause there?
Takings clause was raised, and for the reasons, assuming standing, For the reasons we lay out in our brief, we don't think there's a taking here, that when a manager of public resources like this, which is attempting to protect the resource for everyone, makes a decision to reduce, in this case, to require a particular subset of the fishery to abide by the rules that other subsets of the recreational fishery already have to abide
What's the
by.
remedy for taking?
Pardon?
What's the remedy for taking?
Normally, it would be to bring an action in the Court of Claims, and that's another issue. It would not be to say that the agency's conservation rule is invalid.
In other words, can you get injunctive relief
Right.
through taking?
I don't think so. I think there are a lot of problems with the claims here, and so I want to take seriously because they're all consequential. We think the commission believes that the rule that's attacked here, Addendum 2, is important to conservation. Obviously, most consequential is the claim that everything the commission's done for decades. And this is, I would submit that there is a sort of fashion right now to sort of attack institutions and claim that institutions that have been working well are somehow fundamentally, defective. And I think we should be very careful about entertaining those kinds of claims, particularly when they haven't been raised in the normal legal process
And your
and
response as
briefed.
to whether the ASMFC itself is unconstitutional is probably preliminary, that you don't think it's in that complaint.
Correct. We dispute, we think it is, it is a compact that's been around. It reflects sort of double legitimacy in our system. It is, the states have approved it, and Congress has repeatedly approved it, and Congress has enacted, it is true, subsequent legislation that recognizes that the commission exists and has certain capacities and works with states. And the states from Maine to Florida, red states and blue states, have worked cooperatively on really hard issues that almost necessarily cause pain sometimes when we're trying to protect a common resource, and it's never completely clear what the right answer is, but the commission has a process to arrive at answers that are that reflect everyone's input. In this case, there were 2,000-something comments just on Addendum 2, the very sort of short-term measure at issue here. There were many thousands more on Amendment 7 that sort of set up the framework. And so we think that, before anyone sort of casually says this whole process is unconstitutional, at least it should be properly pled and briefed by parties and so forth. So I think we win that argument, but I also think it's not even properly presented.
All right, let me ask Judge Floyd, do you have any more questions, Judge Floyd?
No, sir.
Judge Thacker? We'll thank you for your
Thank you,
argument. We'll hear some rebuttal from the applicant.
Thank you, Your Honor. We do have our complaint here electronically. My glasses on. Said the interests of the plaintiffs have been adversely affected,
What paragraph are you reading from?
9.1.
9-1?
The interests of the plaintiffs have been adversely affected and, oh God, I have to do this right, and manifest injustice has resulted from defendants' arbitrary, capricious, and unconstitutional action. And I do want to make up,
Their actions, but that, so that, I think Judge Floyd's question was whether you had raised below or in your complaint your allegation that the entire commission's is unconstitutional.
we did not in our complaint.
Okay, 'cause he
We
couldn't
did
find
in
it and he
subsequent
was
court-
correct.
We did in the subsequent court documents. And on the compact issue, I do want to read this, Congressional Research Service, which is a bipartisan organization that surveyed these, and they said this in one of their recent reports.
Is that in the joint appendix, what you're reading from? Is that in the record?
I'm almost certain it is, Your Honor. I'm sorry, I can't
Almost
cite
certain
it
what
all.
it is?
Well, it is. And I have the document, in fact.
Oh, okay,
with
well,
me.
go ahead.
So it says that the compacts can preempt inconsistent state law, going to the state law question, but no court may order relief inconsistent with the compact's terms unless the terms violate the Constitution. And we set forth this constitutional objection, and while it was an additional argument in our subsequent documents to the court, to make that we are under the standard rules of federal procedure, I think, allowed to make additional arguments on the same principle, the U.S. Constitution, in this case. And that's all what we are doing here is saying these grounds were unconstitutional. Here were the reasons in the complaint. Here's what we said in the documents. And here, the anti-commandeering argument, I think, is unaddressed in all the cases that have gone before us, and is appropriate for us to get back there and argue with the merits in the meantime. Right now, we're looking at developments with respect to the 2025 fishing season, and our clients' customers are sitting on the sidelines again, as they did as soon as they heard the news that they were only allowed to catch one fish versus the way they've done it in the
Well,
past
they
15
can
years.
catch more than
I'm
one,
sorry?
they just can't keep more than one, correct? They can catch and release as many as they want, right? They just can't keep more than one.
Well, you could release it, yes.
Right, yeah.
Yes, you're right about that, but people want to catch the fish, take a picture of it, and take it home and eat it.
Sometimes.
Thank you for your time, Ron.
Thank you very much. Thank you both, counsel, for your arguments today. Mr. Terra, Mr. Donahue. Court is going to come down and greet counsel. And Judge Floyd, you prepared to go to the final case?
Yes, sir.
And we will go to the final case for the day. All right, we're prepared to hear arguments in the final case for the day, Kaufman versus Nextstar. We'll hear from Appellate's counsel, Mr. Atkinson.
Thank you, Your Honor. May it please the court, I'm Mark Atkinson. I represent the plaintiff below, Ms. Kaufman. There's one point of law that is substantial and controls this case that everyone agrees upon. Plaintiff's counsel, defense counsel below, the district court in its order, the Fourth Circuit in its opinion, and that is that at a summary judgment stage, all facts are to be interpreted in the light most favorable to the plaintiff, or the non-moving party in this instance was the plaintiff, and even inferences that can be taken from those facts are to be interpreted in the light most favorable to the plaintiff. The standard of review here is de novo, and this court has that same standard before it. We have presented 7 different factual issues where the court did not follow that standard, and in fact, we suggest he did the opposite, that he strained to come up with arguments in favor of the defendant. If just one of those factual issues this court determines in our favor.
What do you think is your primary factual dispute that the district court improperly considered in your view?
Yes, we think the most important one is that the court ruled that Ms. Kaufman's request to work remotely a second time after she had worked remotely 2 or 3 months earlier was not a reasonable accommodation. And we think the court erred for two reasons. Number one, that's a factual issue. It's not for a trial court to make that determination. Number two, if you get past that and you're interpreting these facts in the light most favorable to the plaintiff, she had just worked remotely 2 or 3 months earlier. She had worked remotely from a hospital bed 2 or 3 months earlier.
Appellee alleges that she didn't meet her sales goals when she was working remotely.
Well, that was not, she clearly met her goals in her testimony. She felt that she did, as I recall.
So perhaps, in your view, that's another factual dispute.
It is a factual dispute, we believe. Thank you, Your Honor. That's one issue. A second issue is that the district court erred in concluding that Nextstar did engage in the interactive process. When a reasonable accommodation is asked for, the law is clear that the employer has to engage in an interactive process about that reasonable accommodation. And what's clear in this case is Nextstar didn't say a word about that. They did talk about other issues with her, but they never
They
discussed.
let her work remotely. She used her, her Family Medical Leave Act. She used short-term disability. They were working with her, and then the last communication from her really indicated she wasn't coming back because she has all these issues. She had another surgery planned that would be 4 to 6 weeks, and then another tentative surgery in October. There's no indication that she says she plans to come back in that last August communication.
No, we disagree with that, Your Honor. She had worked remotely. 2 months after her surgery, when her ureter was cut, she asked again to work remotely. There's not one word of interaction by the defendant about working remotely. All they were interested in was her coming back full-time. She had a nephrostomy tube in her back, and she could not drive, but she easily could have worked remotely again. And the communication the court's referring to is her August 4th, 22 letter. She said, I'm scheduled to have a surgery on August the 8th, and she puts in that email that she may be able to come back in September or October. So we don't think that is an unreasonable response that she gave to that point. She felt her job was being threatened at that point. And even if the court wants to take that August 4th letter as an issue of fact, it's one issue of fact of all kinds of issues of fact that a jury should have considered. A third issue of fact, the district court ruled that driving was an essential function of her job. We think that's clear error for two reasons. Number one, it's not up to the trial judge at summary judgment stage to determine what's a critical issue of fact or essential function of the job. We cited the case law for that. Number two, if you are going to say when she had just done it 2 months earlier.
When is it that appellant intended to return to work?
She went to her doctor. She was going to have surgery on the 8th of August, and she said in September or October, I should be able to come back. As in any case, Your Honor, she has to talk to her doctor and release her. She was actually released in September fully to go back to work. She could have worked remotely months before that.
When did, let me ask you two questions. One, when did Kaufman exhaust her job protected leave?
I'm sorry, when did she exhaust?
You got the question. When did Kaufman exhaust her job protected leave?
Well, there are two issues there, Your Honor, and those are other factual issues that we think should have been decided by the court. She was on disability leave when she was fired. She was fired on August the 19th. She was on protected leave for disability leave until August 24th. She was then eligible for paid parental leave starting August 24th, 5 days later. So to answer your question, she had not exhausted her leave that was available to her. She was fired before that was exhausted.
Is disability leave protected leave?
Well, it's a factual issue that a court could consider or a jury could consider.
Consider what? Whether it's protected leave? It's either disability leave is protected leave or not, is it?
I think the only answer I can give to the court on that is it is evidence that the employer has an illegal motive to fire someone while they're on protected leave. And in this case,
When you use the term protected leave, I don't know of anything to establish that disability leave is protected leave.
well, we think I don't know of any case that uses those words, Your Honor. But if you're on disability leave and the employer says, as they've said in this case and is in the record, we normally don't fire people on disability leave. We think that is.
My second question would be, are indefinite accommodations reasonable?
Yes, the accommodation she asked for was to work.
Indefinite.
Oh, no, it's not. And we don't think it was indefinite in this case. She told them on August 4th, I'm having surgery on the 8th, and it looks like I will be released in September or October, and she was actually released in September.
Didn't she also say she had another tentative surgery in October?
Tentative, and then she did not have that. And basically, that was to remove the nephrostomy tube.
But that's what she told
She
the
did.
employer.
She did. But she was it has to be a reasonable time, and we think, and we submit, particularly if this court is viewing things in the light most favorable to the plaintiff, for her to say in August, I should be able to come back in September or October, that's reasonable.
Where did she say that? In the email?
Yes. The email of August 4th.
Should be able to come back in September.
Well, she's talking about how long she'll be out, and we think that's the same thing.
Do you mean where she says requiring a recovery time of 4 to 6 weeks as well as another tentative surgery in October?
Yeah. And I think below that, she talks about, if I remember correctly, she talks about September or October.
But she's got surgery in October.
She may have surgery in October. She has surgery on August the 8th. She said there may be another surgery, and there was not.
Yeah, but the employer didn't know
That's
there
correct.
was not going to be another surgery.
That's correct.
What the employer knew was that she said she has a tentative surgery in October.
That's right.
Which would be additional time, even time beyond that.
That's right. That's right. We agree with that. But we think that's a reasonable time, particularly if you interpret the facts in the light most favorable to the plaintiff. Another error that we feel the district court made was and I'm going to quote from the order. He says, inasmuch as Ms. Kaufman's August the 4th, 22 email failed to provide Nextstar with a definitive date upon which she could reasonably be expected to return, that is not a reasonable accommodation. There's no court in the land that says she has to provide a definitive date.
I think you're granted that point, but what is reasonable? Is 6 months a reasonable period of time?
I don't think she was asking for 6 months under these
Would
records.
6 months be reasonable?
6 months from when, Your Honor?
For her to be out? Or the time period you're saying? We said it's not indefinite, but a time period of 6 months be reasonable?
Well, she asked on August the 4th, or she responded to them, here's what my medical condition is. And there's nowhere in there that that's going to be 6 months. So we don't think 6 months.
She'd already been out 6 months.
She had.
In fact, they gave
Now,
an
9
additional
months.
12 weeks.
That's correct. That's correct. But as of August 4th, they were communicating to her about when can you come back. They weren't firing her. If 6 months was the rule, they would have fired her before that. They're not doing that. They're looking at, in August, when can she come back? And she answered that as best she could. As in any person who's on disability, I have to go to the doctor, and then the doctor will see me, and then I can respond. But she gave them the indication that she thought by October at the latest, she would be able to return. I've already
Would it
mentioned.
be- And in that same, where she does say October, then it says she will have a urethral catheter which prevents me from lifting and driving. And that's right after she says, yeah, no, it says from August 8th to October, I'll have this catheter prevents me from lifting and driving.
Right. There's nothing in there that talks about anything beyond October. That's our point. And we think a month or two is reasonable time. We've already talked about they fired her while she was receiving disability benefits, even though they said they normally don't do that. They fired her 5 days before she was eligible to receive paid parental leave. And the lawyer that fired her, the in-house lawyer that fired her, testified that that 5-day difference, firing her 5 days before she could get on leave, was just a coincidence. And we think a jury could easily infer that that was not a coincidence, that they wanted to fire her before she got on that leave. But in any event, that's a jury question. The district court erred in finding that when her boss said, we quote, we are trying to keep you off FMLA, that's not indicative of an illegal motive. If you interpret the facts in her favor, the words are clear. We don't want you on FMLA. She got on FMLA and she was fired. For all those reasons, that's 7 that we listed. If any one of those this court feels, if you interpret the facts in the light most favorable to the plaintiff, the judge overstepped his bounds, he should be reversed. In this case, should go forward, she should have her day in court. And just one final point. We're arguing about, is this reasonable or is that reasonable? And the real answer is, these are jury questions. If we're arguing about the facts, it's a jury question. And for those reasons, we ask that this order be reversed. Thank you.
Thank you, Mr. Atkinson. We'll hear from Mr. Muntz.
Thank you, Your Honors. Good morning. May it please the court, my name is Andrew Mons, and I represent appellee Nextstar Media in this case. As we just heard from Mr. Atkinson, appellant's appeal is based on contentions that the district court erred by awarding Nextstar summary judgment on all of appellant's claims. However, as Nextstar notes in its brief, appellant fails to cite any actual Fourth Circuit cases that the district court failed to follow. This is because the district court followed Fourth Circuit case law, which supports its conclusions in this case. Appellant's primary argument, as we just heard from Mr. Atkinson, is that the district court did not interpret the facts in the light most favorable to appellant when assessing the summary judgment motion. However, this is simply not true. The district court clearly acknowledged this standard when assessing the summary judgment and in awarding summary judgment to Nextstar. The standard does not require the court to ignore facts, take facts out of context, or draw unreasonable conclusions from the facts. This court has been very clear. Permissible inferences must still be within the range of reasonable probability.
So what exactly must an employee show to prove that they will not be out indefinitely?
Well, I think, Your Honor, the first thing that they need to do is show some time frame when they expect to be able to return. And we just talked about the August 4th email that Ms. Kaufman sent to Nextstar. It's JA184. And looking at it verbatim, there's no indication in that email that she is expected to return at any point. There's a whole series of medical procedures that she lays out that she's going to have, including a surgery that she says may occur in October, and no return date, no expected return date at any point in that email. And bear in mind, as the court noted during Mr. Atkinson's argument, at this point, appellant had been out on leave for 6 months. And to answer Judge Floyd's question, her job-protected leave ended May 18th, 2022. That was when her FMLA ended. She was on a short-term disability insurance policy after that, but the record is clear, and testimony from Nextstar's counsel was clear, that that is not job-protected leave. That is an insurance policy that gives employees income, or former employees, if they were injured, if they have an injury that qualifies under the
What
policy.
does it mean to have job-protected leave as opposed to an insurance policy type?
I mean, Your Honor, I take it, and I think the courts have taken it as it means that you have some legal entitlement to return to your job at the end of that leave. That's what FMLA allows someone to do for 3 months. And she was given that for 3 months, and then 3 additional months, she was allowed to still remain out in her job.
So once an employer goes through, provides all of the required leave, the FMLA, and then the disability protective type things, or if there is such a thing, once that occurs, in the place that she is now, was she in a at-will status?
Well, yes. I mean, I think she's an at-will employee under any circumstance, but I think as far as the leave situation, how from a leave standpoint and from a legal standpoint with respects to FMLA, is employees have a protected period of time where they can be out of work, and then at the end of that period, they have a legal entitlement to be able to return to work if they can. And that's 3 months. That ended for her on May 18th. And then employers, either as an accommodation or just through the goodness of their own heart, can allow someone to remain out. And that's not required by any law other than maybe as an accommodation under the ADA or the West Virginia Human Rights Act in this case. But it's not a requirement that the law says for a certain period of time that person must be able to return to work,
So
like the FMLA
question is
does.
whether a reasonable accommodation existed at the time she was fired?
Yes, that is what the district court.
Who bears that burden?
It's plaintiff's burden to show a prima facie case for her disability claims that she requested a reasonable accommodation and was a qualified individual with a disability. She could not do the essential functions of her job. That is. I know Mr. Atkinson disputes that, but it's really not in dispute. No one disputes that driving was part of the job and a requirement of part of the job. And generating new business was a critical part of the job, if not the most critical part of not only this job, but Nextstar, who's it owns television stations and sells ad revenue to make money. That's the bread and butter of their business, more or less. So generating new business and driving out into the field and meeting with individuals is a critical part of the job. And this is Beckley, West Virginia, where she was located. She's not in New York City where she could, get from here place to place without driving. She needed a car. She needed to be able to drive to places. She needed to be able to meet with clients and potential clients to make sure that they're advertising with the station, to make sure that they're happy with the station's services. No one really disputes that, including Ms. Kaufman in her own deposition testimony disputed that being able to drive, going out, meeting, generating new business was a critical, essential part of the job. And just regarding the essential functions, just another put on, she was allowed to work remotely for a 2-month period in late 2021, early 2022. We do not dispute that. She was allowed to do that, but that does not mean that those no longer became essential functions of her job. An employer can tell someone you can temporarily not do essential functions of your job But that doesn't erase the fact that they are essential functions. Even the Equal Employment Opportunity Commission, in its own guidance, makes that very clear. And that is something that was common during COVID, where employees maybe were allowed to work remotely for a period of time, maybe certain duties were excused, maybe certain things that they normally would have to do that were critical parts of the job that the employer just had to bear that they couldn't be done at that time. But that didn't mean they weren't essential. And regarding her allegedly asking her manager about being able to work remotely around the April-May timeframe, assuming that was true, what is, as articulated in our brief, the intervening events, and as shown at JA 104, Ms. Kaufman's own email, there were several intervening events at that time. She had multiple surgeries and potential surgeries after she allegedly told her manager that she would like to try to work remotely. As of August 4th, which is after this email was sent, when Nextstar determined it needed to separate her, there's no indication that she could or would work remotely. There's nothing in this email that indicates that. And this email was in response to an email from Nextstar's counsel about Ms. Kaufman's ability to return to work. So Nextstar, when it made the determination, had no indication she could work remotely and any ability to work remotely. And even if she could, as we note in our brief, that would not have allowed her to do the essential functions of her job, while her manager testified that for a couple months in that December, January time period, he could excuse her to not go generate new business. At that time, she had business that she had built up earlier in the year. That period's a little bit of a slow period as far as business generation, with the holidays and things like that. But that didn't mean someone could do the job on a longer term basis or at a different period of time in the year without being able to go out in the field and generate new business and meet with clients and potential clients. Regarding the arguments with Nextstar's paid parental leave policies, the district court quotes a rather long portion of the transcript of Nextstar's counsel explaining exactly what that paid parental leave is. And when it comes down to it, it is not, once again, a job-protected leave or a benefit that gives someone the ability to stay out longer than they otherwise would have. As is explained by the district court in its decision granting summary judgment, this is essentially a way to pay someone who's either on maternity leave or paternity leave. It's a 6-week paid period. So typically, as was explained, if someone gives birth, maybe they're able to get paid through short-term disability for the first 5 or 6 weeks after they gave birth because they're unable to physically work at that time. They could stay home with their baby for an additional 6 weeks, and the paid parental leave gives them the opportunity to get paid for that. It is a fringe benefit offered to employees. It is not once again, a job-protected leave or a way to stay out on leave for an additional time when someone has been out for 6 months, as was the case here. It is largely a red herring that is not related to any sort of leave that Ms. Kaufman could have gotten to allow her to remain out of work and not doing her job. As I noted with the short-term disability, it's an insurance policy. It's not paid protected leave. Nextstar did not deviate from any policies in terminating Ms. Kaufman while she was on short-term disability. Even the statement that appellant points to by Al Sarbre does not on its face indicate that there was any policy that you couldn't terminate someone when they were on short-term disability. I believe he says in most circumstances he wouldn't terminate someone while they're on disability. But Ms. Kaufman doesn't point to any policy or anything that protects someone and says you cannot be fired while receiving benefits under this insurance policy. In fact, to receive benefits under the insurance policy, the person largely has to say they cannot work. They are unable to work at that time. So it is not a situation where it is impossible for someone to lose their job if they cannot do their job, and there's no period where they indicate that they can come back anytime soon if they're just by the chance they happen to be receiving short-term disability benefits at that time. And with interactive process, as the court noted with Mr. Atkinson, there was lots of communication with Ms. Kaufman about her situation, about her being on leave, about her need to take leave. She's the one who broke off communication, said basically talk to my lawyer, and that was in late June. Whether there was a deficiency in the interactive process because she didn't hear back from someone specifically about the remote work request that she allegedly made, that is not an issue that would give her the ability to win a disability discrimination case. As this court has said, the amount of interactive process that's needed is a case-by-case situation. It's not an ends into itself. There's not a claim specifically that you didn't do an interactive process. It is what the employer needs to do to gain the information they need. As I said, remote work, she couldn't do her essential functions of her job, and her employer was in multiple times communicating with her about her leave and her need to be out, as is evidence.
Let me ask Judge Floyd, do you have any additional questions?
No, sir.
Just that.
No.
Ms. Munch, I think we understand your argument.
Thank you, Your Honor.
We'll hear rebuttal from Mr. Atkinson.
Thank you, Your Honor. Mr. Mons says that driving was an essential function of the job. It wasn't an essential function of her job from November till her twins were born on February 23rd. It was fine for her to work remotely. It wasn't an essential function of
But
the
that
job.
was the time period when she wasn't meeting her sales goals.
That's their allegation, correct. It wasn't an essential function of the job when other members of the sales force could work remotely. So to claim it's an essential function of the job, we think doesn't meet the facts. Furthermore, the law's clear that that's not for a judge to decide. These are jury arguments. The judge is not supposed to determine what the essential functions of a job are. That's a factual determination by definition. And for that reason alone, it should be reversed. Mr. Mons says that the plaintiff allegedly asked for reasonable accommodation. The facts that this court has to take in the light most favorable to the plaintiff, it's clear that she testified that she did ask for that. And they never responded to her about working remotely the second time, ever. They did respond to her about her medical issues.
Who bears the burden of determining whether reasonable accommodations existed? Who carries that burden?
The burden begins with the plaintiff.
So the plaintiff, from a summary judgment perspective, at least the complaint would have to establish as a matter of law that you have met that burden.
Yes, Your Honor. And we believe that is easily done by she worked remotely, she asked to work remotely again, and then all these issues are factual issues that have to go to a jury. That's the crux of our argument today. Over and over and over, Mr. Mons understandably doesn't talk about any legal issues. He's arguing the facts. This is a summary judgment case, and we believe summary judgment is only appropriate where there are no factual issues. Well, all that this court has heard all day on this case is the factual issues. For that reason, this order should be reversed. Thank you.
All right, thank you, Mr. Atkinson, and thank you, Mr. Muntz. The court will come down and greet counsel, and then we will recess until tomorrow morning for court. Reconstitute Judge Floyd to discuss cases in this venue.
I'll be here.
This honorable court stands adjourned till tomorrow morning. God save the United States and this honorable court.